In a significant development, a constitution bench of the Supreme Court of India today, by a 3:2 majority, has upheld the validity of the 103rd constitutional amendment, which introduced 10% reservation for economically weaker sections in education and public employment, popularly known as the EWS reservation. While Justices Dinesh Maheshwari, Bela M. Trivedi and J.B. Pardiwala have upheld the 103rd constitutional amendment, Justice S. Ravinder Bhat wrote a dissenting judgment to strike it down. Chief Justice of India UU Lalit has concurred with this minority view of Justice Bhat. We have covered this particular ruling in our earlier video, the link to which has been given in the description box below. Please do check it out. In this video, we will have a look in detail at the views expressed in the dissenting judgment. In their dissenting judgment, Chief Justice of India UU Lalit and Justice S. Ravinder Bhat have said that reservation on economic criteria is per se not violative. However, excluding the poor among SC, ST and OBC from economically backward classes on the ground that they have enjoyed benefits, the 103rd Amendment practices constitutionally prohibited forms of discrimination. On the question as to whether the 103rd Constitution Amendment is violative of basic structure for providing reservation solely on the basis of economic criteria, the dissenting judgment has held that the state's compelling interest to fulfill the objects set out in the directive principles of state policy through special provisions on the basis of economic criteria was legitimate, and thus introducing an economic basis for reservation as a new category is permissible. Answering the next question as to whether the amendment is violative of the basic structure for excluding the poor among the SC, ST, OBC categories from the EWS quota, the dissent stipulates that the exclusion of backward classes was violative of basic structure. On this note, Justice Bhat has stated, and I quote here, "The othering of socially and economically backward sections, including SCs, STs and OBCs, by excluding them based on no other ground but that they enjoy pre-existing benefits, is to reap fresh injustice based on caste disability. The exclusionary clause operates in an utterly arbitrary matter. First, it others those subjected to socially questionable and outlawed practices. Secondly, for the purpose of new reservations, the exclusion operates against socially disadvantaged groups absolutely by confining them within their allotted reservation quota. Thirdly, it denies a chance of mobility from reserved quotas based upon caste discrimination to a reservation benefit based only on economic criteria. The entire exclusionary principle is Orwellian, so as to say that all are entitled to be considered regardless of their caste or class, yet only those who belong to other classes or caste would be considered and socially disadvantaged classes would be ineligible." At the very outset, Justice Bhat, while regretting his inability to concur with the views expressed by the majority, emphasized that the Supreme Court has for the first time in the 7 decades of the Republic sanctioned an exclusionary and discriminatory principle. He has said that the impugned 103rd Constitution Amendment furthers the language of exclusion and violates the principle of justice and thereby the basic structure of the Constitution of India. Elaborating further, Justice Bhat has observed that the application of the doctrine of classification differentiated between the poorest sections of the society, that is one segment which consisted of the poorest of forward classes, and other the poorest who were subject to additional disabilities due to caste stigmatization. He has also stated that the amendment was keeping the latter out of the new reservation benefit by making us believe that those getting social and educationally backward based reservations were somehow more fortunate. This classification, as per Justice Bhat, was clearly contradictory to the essence of equal opportunity. The dissenting opinion has further highlighted that the benefits granted to backward classes under the Constitution of India could be understood as a free pass, as they were a reparative and compensatory mechanism meant to level the field, granted to those who had been unequal due to social stigmatization. Justice Bhat, while reading out the dissent in open court today, also stated that excluding backward classes from the ambit of Articles 15 Clause 6 and 16 Clause 6 violated the non-exclusionary and non-discriminatory facet of the Equality Code, which thereby violates the basic structure of the Indian Constitution. Pertinently, the dissenting judges have also clarified that granting benefits to the destitute or economically weaker sections of the society was not impermissible. However, it was the exclusion of backward classes from such benefits which was impermissible. Justice Bhat has opined further, and I quote here, "Destitution and economic poverty are markers of intelligible differentia forming the basis of the classification of which the impugned amendment is premised, on which ground the constitutional amendment is indefeasible. However, by excluding a large number of equally poor and destitute individuals based on social backwardness on legally acknowledged class stigmatization, the amendment practices constitutionally prohibited forms of discrimination. The overarching principles on which Articles 15 Clause 1, 15 Clause 2, 16 Clause 1, 16 Clause 2 are based on is that the practice of discrimination is impermissible. Such exclusion strikes at the heart of the Equality Code, specifically the non-discriminatory facet." The dissenting opinion has further highlighted that as per the Sinha Commission report, which was published in July 2010 based upon the census of 2001 and the statistics of 2004 to 2005, in all 31.7 crore people who were below the poverty line, the SC population was 7.7 crore, which is 38% of the total SC population. The ST population was 4.25 crore, which is 48% of the total ST population. The OBC population was 13.86 crores, which is 33.1% of the total OBC population in the country. And the general category was 5.5 crore, which is 18.2% of the total general category population in India. Accordingly, Justice Bhat has observed that these facts establish that the bulk of the economically weaker sections of the society belong to the classes which are described in Articles 15 Clause 4 and 16 Clause 4 of the Constitution. Regarding the question as to whether the state can make provisions for reservation for admission in private and unaided institutions, Justices Bhat and CJI Lalit's opinion concurred with the majority. They were of the opinion that private and unaided institutions may not be state or state instrumentalities, but these institutions also constitute material resources of the community in which the state has a vital interest. Justice Bhat has also stated that caution has to be exercised in dealing with the issue pertaining to the 50% ceiling limit, as the breach of 50% limit was the principal ground of attack to the 76th Constitutional Amendment of 1994, which had been challenged in a batch of petitions pending before the Supreme Court. Therefore, while exercising caution in this regard, Justice Bhat has stated that permitting the breach of the 50% rule would become a gateway of further infractions, which in fact would result in compartmentalization. Referring to the landmark judgment of the Supreme Court in the case of State of Madras versus Champakam Dorairajan, Justice Bhat has further underscored, and I quote again, "The rule of equality would then be reduced to the right of reservation, leading us back to the days of Champakam Dorairajan. In this regard, the observations of Ambedkar have to be kept in mind that reservations are to be seen as temporary and exceptional, or they could eat up the rule of equality." While concluding his dissent, Justice Bhat has stated that the fraternal principle was deeply embedded in the nation's ethos as well as culture. Quoting from the judgment in this regard, the specific provisions which form part of the Equality Code are inextricably entwined with fraternity as well. It is fraternity and no other idea which says that ultimately all individuals are human beings, all go through the same natural process, subject to the same physical limitations, and finally will leave this world. The idea of fraternity is to awaken the consciousness of each member of society that the institutions which are created, the ideas we develop, and the progress we want cannot be without cooperation and harmony. For more information on this verdict, You can refer to our detailed reports, the link to which has been given in the description box below. Thank you. I'm Maratrika Bhaumik for LiveLaw. Keep watching LiveLaw for more such updates.